Are prosecutors using the lyrics from black music, be it rap music, R&B music? Are they using this music? Are they using the lyrics from this music to disproportionately, unfairly, unjustly prosecute black artists? That is what I'm going to talk about today. Stay tuned.
That Corbin and Corbett legal team fighting for the rights of the people. That father-daughter team investing in the youth when the system ain't treating them equal. Providing truth for our people, we able to reach them. So anytime you get accused for a crime and Lord knows you ain't do it, we here to get you through it. Exemplifying prudence and glorifying God, making sure you're compensated for other people's doings. Our vision is to be one of the best. We're small enough to focus on your matter throughout the neighborhoods of Dallas. Working constantly and making sure your rights are protected. A firm team of lawyers, aggressive, effective. A team that has your back in the courtroom. Two well-spoken black lawyers in the courtroom. Investing time and resources when it's evident that you were treated wrong. Now you walking out of Dallas courtroom with a settlement. Corbin and Corbett, the father-daughter legal tag team that has your back in the courtroom. Our purpose is simple. To obtain the favorable outcome for each client and glorify Christ in all we do. Our vision is to be one of the best and most...
Hello, everybody. Hello, everybody. This is Attorney Augustus Corbett. I am one half of the Defiant Lawyers. Each week, we bring legal analysis of trending politics, policies, personalities, and pop culture to empower you with the information you need to defy this unjust legal system. If you are not a subscriber, please go ahead and subscribe, like, share, and comment. We got a power-packed show for you today. We're going to talk about the fact that prosecutors oftentimes use lyrics from black music to go after black artists. And we're also going to give you a very, very important update on the Breonna Taylor case. And time permitting, we're going to talk about all that went on this week with Donald Trump. It is quite extraordinary what is happening with the former president. Quite extraordinary. In fact, unprecedented is the word that I would use. But before we get into all of that, I want to remind you one more time, go ahead, subscribe, hit the subscribe button. We're trying to grow a channel that is different from most channels. Dare I say, from any channel that I've seen. And that is, again, we want to give you each and every week information, legal information, that is from the African-American perspective. That's from the black perspective. I'm telling you, the law seriously impacts our life on a daily basis. And so it's our mission statement to empower you with the information you need using trending legal matters involving politics, policies, personalities, and pop culture. We use those to give you that empowering information. It is so very, very, very important. Very important. Now, okay, let's see. Where do we want to go? First of all, let me point out that I am alone today. I'm riding. I'm alone. I don't have my ride or die with me. Attorney Chloe Corbett, my law partner, and my daughter. I am doing it all by myself. She is today out of state, actually, and she's having a good time while I carry this burden alone. But listen, the information is going to be very, very powerful. Okay? All right, now let's see if we got everything set up. Let's see if everything is working the way it needs to work. You all have heard of Young Thug, and you've certainly heard of R. Kelly. We're going to briefly talk about those two gentlemen today, as I talk about something called the RAP Act, a new law that has been proposed in the U.S. Congress to address the issue of whether prosecutors disproportionately go after black artists who have some questionable lyrics in their music. All right. So legislation has been proposed, and I'm going to talk about that legislation here in just a moment. All right. So first, what are we doing here? All right, so let's begin with, all right, where do I want to begin? Let's begin with Breonna Taylor. All right, so let's go to my presentation. You all just work with me because I'm hosting alone and I'm also producing at the same time. It's no issue. I do it all the time, but just work with me, okay? I don't have 50 people in the background here who's doing the camera and doing the audio and doing the producing. I'm doing it all. So just work with me. No problem. I'm going to get this information to you. You're going to get this work. Like the young folks say, you're going to get this work today. Just stay there and work with me. You're going to be better. You're going to be better off after I finish this broadcast because your mind is going to be expanded. You're going to know things. I guarantee you that you didn't know. If you want to chime in to this conversation or to this monologue, but if you want to get in on this, please go to YouTube or Facebook and make your comments, and I will recognize those comments. We have comments already coming in. So, okay. All right. Yes. So already, Tiffany Raleigh, she says, hello, haven't been here in a while. Well, Tiffany, where you been? Where you been, Miss Raleigh? You have been missing a lot of stuff. So make sure you go back and you listen to the broadcast from the previous weeks. You have missed a lot. But anyway, welcome back and thank you for commenting. All right, let's go to our presentation. Decriminalizing Black music. Decriminalizing Black music and holding Trump accountable. And we're going to talk briefly about the Breonna Taylor case. There's a lot going on with her case. Very important stuff. All right. So let's go to her first. And I'm also going to see if I can get my wife on the line to update us about Breonna's case. All right. So you see three individuals here. You see Breonna Taylor. You also see a detective for the Louisville Police Department, Metro Police Department. And you see an African-American gentleman with a big smile. He is the Attorney General of the state of Kentucky. And he handled the investigation of Breonna Taylor's death. And as we all know, essentially, he brought no charges against any of the four defendants for killing Breonna Taylor. One of them was charged with discharging a firearm in someone else's house, but Breonna Taylor, no one was held accountable for her death. Well, a week or so ago, we talked about it last week. Go back to that tape, and you'll see that the United States Department of Justice brought charges. Shout out to Merrick Garland and to Kristen Clark, who is the Assistant Attorney General over the Department of Justice. They brought charges. And you know what? Shortly after they brought charges, we got the news that the detective that was on the screen, I'm gonna put it back up in just a second. That detective is going to plead guilty to lying on the search warrant, on that no-knock search warrant. She's going to enter a plea of guilty. That's what's being reported, for lying on that search warrant. That is big, because in these criminal cases, it's like the domino effect. If the government can get one person to testify or to plead guilty, oftentimes that means that that person is going to testify against the others. So I'm quite sure she's worked out a deal to talk about everything that they did, misleading and false, that they placed in that search warrant that led to the death of Breonna Taylor and endangered other people in that apartment complex. So that's big that she is scheduled to plead guilty. Okay. Now, let me go back over there, because I do want to see if we can get my lovely wife on the line, and so she can kind of brief us about this development. Okay, let me see if I can get her on the line. Just hold on with me here. Okay. All right, so just work with me here. All right, sweetheart, are you there?
Yes, I'm here.
All right, glad to have you on the line with me.
Well, thanks for having me.
Well, yeah, absolutely. We want to hear some more about the Breonna Taylor update. Would you update us, please?
Yes, definitely. I was very um, furious last week, and even more so furious this week because, as you stated, former Louisville detective Kelly Goodlett, Goodlett, it has been confirmed with her by her attorney and one of the DOJ's attorney that she is going to plead guilty to the charges that were leveled against her.
Okay. And
She's due.
go ahead. I'm sorry.
Yes, she's due. She's scheduled to appear in court on August 22nd.
To enter her plea of guilty.
Right.
Wow. That's really, really, really big.
It is. It's very big. Now, there were three other officers also charged. They have the more serious charges against them. From what the Washington Post is reporting, what she's charged with, what ex-detective Goodlett is charged with, carries a maximum of 5 years in prison and a $250,000 fine.
Okay.
But the other three officers, Sergeant Cal Meany, 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 and former Detective Joshua James, and former Detective Brett Hankerson, they are charged with more serious civil rights offenses, according to the Washington Post, and they could face life sentences if they are convicted.
Okay. All right. Okay. So now I'm going to put back up on the screen here Daniel Cameron, who's the AG, who was the person who investigated the Breonna Taylor case. And what are your comments regarding Mr. Cameron?
Yeah, it's just like I said last week, it's just awful that his investigation did not discover, or if they did discover, these events that happened leading up to falsifying an affidavit and then covering up the falsification of that affidavit is just so mouth dropping and makes you just furious. As I stated last week, all of these people take oaths that they will uphold the law, and it appears that they didn't. And even some of the grand jury members are represented by lawyers. I think at least 3 of them, according to the Washington Post, are represented by lawyers because they were very upset with Attorney General Cameron, the fact that he did not allow them, the grand jury, to expand the charges. They wanted to look into what led up to the search warrant, but they were not allowed to do that, according to the Washington Post, because Attorney General Cameron would not allow that. And just as a side note, this gentleman, Attorney General, is running for governor there in the state of Kentucky. And that election would take place next year, I believe.
Okay. Well, you're being nice again, and I'm going to be nice too. There's some other things that we could say about Daniel Cameron, but let's just suffice it to say how they said that all your skin folk ain't your kinfolk.
Definitely. We have found that out. Definitely. So true.
Yeah. So he released a statement last week. We're not going to read it, but basically he said he was his investigation just had to do with the shooting of Breonna
Right.
Taylor and not the actual warrant itself, whether the warrant was executed legally.
So let me ask you as an attorney, okay, if that was the boundaries for his office, somebody in the state of Kentucky should have been able to investigate the origin of the search warrant and if it was truthful or not. I would think. What say ye?
I say what he's saying is garbage.
Right.
It's garbage because if you're looking at whether the warrant itself was executed properly, quite naturally, you would look at whether the warrant itself is legal, because the warrant is established upon sworn affidavits of those officers. And so you would want to know if someone lost their life, you would want to know whether the statements in that affidavit, which convinced the judge to order or permit the no-knock warrant to be issued, whether or not the statements that brought it about are truthful, are honest.
Right.
I mean, that doesn't make any sense, what he said. So I consider it to be hot garbage. And to me, it gives his office and the state of Kentucky a black eye.
I agree.
Yeah, for not only the Justice Department to bring charges, but someone is admitting, yes, we did lie in our affidavits, and therefore the warrant should not have been issued. And Breonna would probably still be alive today, and other people's lives would not have been endangered. And that's why we're talking about it, and that's why this YouTube channel exists, because we don't want this to fly under the radar. We want people to understand, Black Americans, white Americans, Hispanic Americans, Latino Americans, Asian Americans, Arab Americans, whomever, we want them to understand that our nation is a nation of laws, and it's the public's responsibility and attorneys' responsibility to make sure the government plays by the rules.
Right. And not only did they lie in the affidavit, I mean, it was so intentional, at least according to the Washington Post article that's out today. They knew that they needed some updated information. So that's why they lied about the fact that they had verified that there was a more recent suspect which had delivered drugs to Miss Taylor's apartment. They knew that was a lie.
Mm.
Yes, according to the Washington Post. And they say that this Officer Goodlett, the one who's scheduled to plead guilty, conspired with James, the other officer, Jaynes, because they said that the poster inspector had verified that a suspect in a drug investigation was receiving packages at Taylor's address, but they said that they didn't have enough recent information. So they went and added another paragraph stating that the officers had verified even more recent package deliveries. And then once they lied about that to get it signed by the magistrate or judge, after everything that happened and Miss Taylor lost her life, they went and covered that up. The four of these officers agreed to say the same lie about the affidavit. So it was a lie, then a cover up,
Wow.
according to what is to come out. Now, of course, the other three officers, they have pled not guilty.
Yes, and the detective, she reportedly will plead guilty, but she's still presumed innocent, and all of them are still presumed innocent. So these are allegations so far, but it does look like some developments and progress have been made on this case. And I might add one other thing before we let you go, sweetheart, which is Assistant Attorney General Kristen Clark announced that they also are doing an investigation of the entire Louisville Metropolitan Police Department. And oftentimes that will result in, and what they're looking at are the practices and the policies of that police department to see if this is sort of routine, to see if minorities are sort of repeatedly being victimized by these police officers. Apparently, the DOJ thinks so, so they are investigating the whole department for that. And oftentimes, this will result in what's called dissent decrees, where the department will agree to abide by certain changes within institutional changes within the department. So that is also a positive development. And let me just add too, during the Trump administration or during the Obama administration, there were a number of police departments that had entered consent decrees with DOJ. And when Trump's administration came in, they basically got rid of all of them. So police departments had free rein to do whatever they wanted to do. Well, hopefully we're back where the pendulum of justice has swung back over toward police reform and justice, which I want to end this segment by saying, as we said last week, some of your favorite words. In fact, I'll let you say them.
Elections have consequences.
Yes. Yes. Could you say it
So,
again?
yes, elections have consequences, because if this had been a Trump administration, DOJ, they would not, more than likely, we know 99.9%, there would be no chance for this to have been investigated for the last 2 years. Because remember, Miss Taylor lost her life in 2020, and this is 2022. So I'm so appreciative that all of those people, the detectives and the FBI officers, continue to work on this case to uncover this, if the allegations prove to be true.
Yes. All right. Well, thank you for joining me, sweetheart. And you did a great job as always.
Well, have a good show.
Thank
I'm
you.
watching, so I will get back to watching what you have to say. Thank you for having me.
Thank you so
Bye-bye.
much. Bye-bye. All right, let's go back to our presentation now. We're going to go to the second. And by the way, let me shout my wife out for joining me today. Yes. All right. Anyway, that didn't work. But let's go back to my presentation. I appreciate her joining me. Now, let's talk about decriminalizing black music. What am I talking about? What am I talking about? You know, what is and who are these people on the screen? Well, I'm not familiar with the guy that has the glasses. I believe his name is Young Thug, which is his alias. His real name is Jeffrey Lamar Williams, and he is a rapper. Again, I'm not familiar with him or his music. If I've ever heard one of his songs, I didn't know it. But I am familiar with the other two gentlemen. One is Johnny Cash in his younger days, and the other one is Robert Kelly. And what do these three people have in common? Well, they all are artists. Mr. Cash is since passed, but they were all artists, and they all had some things to say in their music that were, let's say, disturbing. Okay, and so let's talk about though how prosecutors though tend to look at their music in a different way. Now, R. Kelly has been charged with a number of offenses, and he's also been convicted, and he has some trials coming up. And I'm not here to talk about his situation specifically or Young Thug. I want to talk about the fact that their music became an issue in their prosecution, and it brought about some legislation that's trying to work itself through the United States Congress. Now, R. Kelly released a song entitled "I Admit It." I admit it. And by the way, I did a video on this particular song several years ago talking about how prosecutors could definitely try to use this song, some lyrics in this song against R. Kelly. Whether they did so, I don't know because I didn't participate in the trial. I'm uncertain. But as an attorney, I'm telling you, when you make statements, be it verbal statements in a song, in a book, on video, or what have you, prosecutors can use those statements against you if they're trying to prosecute you. So it's very unwise to do so. All right. And Young Thug also apparently uh, he also released some songs. Again, I don't know anything about his music, but it's reported that, in fact, the indictment, let me go back and just tell you a little bit about the indictment. On May 9th, the feds indicted Young Thug and someone called Gunna, real name Sergio Kitchens, and a couple of dozen of other people in an 88-page indictment. And they alleged over 50 different charges. And regarding Young Thug, they alleged in the indictment that he's the co-founder of a gang called Young Slime Life, YSL, and that they conspired to commit multiple murders, shootings, carjackings, and so forth. Please, let me remind you that Mr. Williams, Young Thug, Gunna, Mr. Kitchens, and all the other folks who were indicted are presumed innocent. The government has not proved that they have committed any crime, and they have a constitutional right to be presumed innocent. And that means a lot to me because I represent my firm, my daughter and I, we represent criminal defendants. And we remind people all the time, just because the government brings charges doesn't mean that those charges are true. They got to prove those charges beyond a reasonable doubt. So these people are presumed innocent under the law. Now, when I did this video, a lot of people jumped on online and commented that, I'm not from Atlanta. I don't know these people. And, they did this and did that and so forth. Look, I'm not from Atlanta. Been there only a couple times in my life, but I know the law. I know criminal law. And I'm saying again, I'm asserting again that Young Thug, Gunna, and everyone indicted in this indictment are presumed innocent. Now, that said, I want to talk about the fact that the state or is it DeKalb County, I think, that's prosecuting these people are, they included in the indictment reportedly some things that were said in some rap songs. Now, let me bring back up my presentation because the man in the middle, Johnny Cash, Mr. Cash, wrote a very famous song, one that I grew up listening to. It was called Folsom Prison Blues. Folsom Prison Blues. And I listened to it all the time. It had a part in it that said, my mama used to tell me when I was young, she said, son, you be a good boy. Don't you never play with guns. You see, I know the words by heart. But I shot a man in Ringo just to watch him die. And when I see that train a-coming, I hang my head and cry. So that was a song that Johnny Cash wrote. Again, the name of it is Folsom Prison Blues. And that part, that lyric that says, I shot a man in Ringo just to watch him die. Now, look, I don't know if Mr. Cash did that. Apparently he didn't. He was never charged with it, I don't know. But the point is, whites, pop music, not just rap music, because rap music get all of the attention. Rap music has this reputation, this, what they call it, gangster rap. And if you listen to the rap artists, what they'll tell you is, I'm rapping about all of the violence that I see in my community all the time. You see, all the stuff that I grew up having to live with and having to contend with in the ghetto. That's what I'm rapping about. That's what they'll tell you. And my advice as a defense attorney, criminal defense attorney, is I don't care. Don't put that in your music. And, especially if the government may be targeting you, if the government is looking at you, you would not want to go have a song out there that brings attention to you, right? That just doesn't make any sense. But then at the same time, prosecutors should not disproportionately focus on rap music and leave all this other music alone. Because I read a report, I read a study in preparation for this show that pop music, which is mostly whites, and rock music is filled with even more violent lyrics. But we don't hear about that. We just hear about the rap music, right? Some of you probably never heard Johnny Cash's song that he shot a man in Ringo just to watch him die. But you all know these lyrics here in these R&B songs or these rap songs. So, two congressmen, let me pull them up, two African-American congressmen have proposed legislation to prevent prosecutors from using lyrics in songs to convict, people, artists, basically. All right. And there's some things I want to point out to you about their legislation. So here's the actual bill. Right now, it's in the House of Representatives. And those two gentlemen, by the way, Congressman Hank Johnson from Georgia and Congressman Jamal Bowman from New York. So they co-sponsored this bill. And so the bill says to amend the federal rules of evidence. Let me point out first and foremost that this bill only deals with federal cases. So all states don't, the 50 states don't have anything like this, that's matriculating through their legislatures. This is just a proposed amendment of the federal rules of evidence. And the rules of evidence, the purpose of the rules of evidence is to keep certain things, certain statements, certain documents, certain types of evidence from being used against someone in a trial. So let's say somebody says something like the "I Admit" song by R. Kelly. Well, if it's a federal charge, then his attorneys could try to keep that song out or lyrics from that song out of his trial. Could file a motion to and ask the judge to keep it out. For example, in fact, shout out to Chloe Corbett this week, who in one of our cases successfully, we filed a motion to suppress some statements that one of our clients made, and Chloe argued that motion and questioned the detective and so forth, and was able to convince the judge to keep a lot of the statements that our client made from being presented to a jury when we go to trial. That's a really, really, really big accomplishment. All right. This particular legislation is intended to focus specifically on music, on lyrics from music. Okay? So these congressmen want the federal rules of evidence. Let me go back to them. They want the federal rules of evidence to be amended to say basically that prosecutors, federal prosecutors, not state prosecutors, federal prosecutors cannot use lyrics from music against the artists. Okay? Now, it reads, to amend the federal rules of evidence to limit the admissibility of evidence of a defendant's creative or artistic expression against such defendant in a criminal proceeding and for other purposes. So they want the federal rules of evidence to specifically say that someone's creative or artistic expression can't be used against them. Now, there is an exception. There is an exception. I'm going to explain that exception to you in just a minute. All right, I'm sorry. What's going on here? Okay. Sorry about that. All right, so now it goes on, like I said, there's an exception. So be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, Section 1, short title, this act may be cited as the Restoring Artistic Protection Act of 2022. And Restoring Artistic Protection is the acronym for RAP. So the short name of this is, or the sort of the common name, will be the RAP Act of 2022. You need to be watching out for that. In fact, you need to call your congressman. I'm in support of this. And I'm going to tell you why in just a moment. All right. This goes on to say, all right, creative and artistic expressions inadmissible, except, all right, remember I told you there's an exception? So here's some language. Except as provided in subsection B, we're going to look at that, evidence of a defendant's creative or artistic expression, whether original or derivative. In other words, whether it's this artist's original work or whether it's derived from someone else. A ghostwriter wrote the lyrics or something, is not admissible against such defendants in a criminal case except, so this is not a hard and fast rule. There are exceptions. Here's the exception. Except a court may admit evidence described in subsection A if the government in a hearing, so there has to be a hearing, conducted outside the hearing of the jury. The hearing should be conducted outside the jury because if the jury hear the lyric, even if the judge later subsequently says it can't be used, you can't unring the bell. So the hearing has to be held outside the jury, and the moving party, the prosecutor, must prove by clear and convincing evidence, which is a pretty high standard. It's not as high as the beyond a reasonable doubt, but it's not as low as probable cause or preponderance of the evidence. So it's right next to the beyond a reasonable doubt standard. It's below that, but it's pretty high. And subsection 1A, if the expression is original, that defendant, so here's what the government would have to prove, that the expression is original, that the defendant included a literal meaning rather than figurative or fictional meaning. So the prosecutor couldn't use it if it was a fictional expression, like I shot a man in Ringo just to watch him die, and that's just fictional. That's just a colloquialism. Prosecutors couldn't use it. They got to show that this is real. Okay, let's go back. Or if the expression is derivative, that the defendant intended to adopt the literal meaning of the expression as the defendant's own thought or statement. So the prosecutor would have to show that if the artist used someone else's lyric, that they adopted it, that they intended to use this in a literal way. All right? What's second? That the creative expression refers to the specific facts of the crime alleged. All right? That is big. So they couldn't use the lyric unless the prosecutors say and can show the judge by clear and convincing evidence that this lyric points directly to this crime. That this lyric points directly to this crime. So you all are more, you younger people especially, you're more familiar with these rap songs than I am. And you know all the time these folks in these rap songs are saying things, that are violent, but it does not, point to a specific crime. Or maybe it does. And so the congressmen are leaving that exception open, that if in fact they committed a crime and then rapped about it or sung about it in their music, then the judge can rule that is admissible. All right, so not something colloquial, not something mythical, not something imaginary, but it's real and it points to a specific crime. So, if somebody rapped, I shot the guy between the eyes, I stood over him and watched him cry, and I shot him with a 9mm Glock, and then pursuant to the investigation, the state finds in fact that the alleged person shot the person between the eyes, stood over him, and he used a 9mm. If he's foolish enough to rap about that and sing about that in his song, then if this statute passed, if this change is made to the federal rules of evidence, they still could use that lyric against this artist. All right, let's go back. That the creative expression refers to the specific facts of the crime alleged, that the expression is relevant to an issue of fact that is disputed. That's important. So the lyric has to be relevant. We can't, as attorneys, we can't use any evidence that's not relevant to the case, relevant to the issues. It has to be able to prove or disprove some material fact. Otherwise, it's inadmissible, you know. So if the guy raps about or sings about shooting someone in 1990 and the alleged crime is in 2022, that's not relevant. What he said about some song, what he said in 1990 has nothing to do with what happened in 2022. So that's not relevant. So that would be a reason for the judge to say, nope, feds, you can't use it. All right, so let's go back. Okay. And then the third thing, that the expression has distinct probative value or probative value not provided by other admissible evidence. So that means that the evidence is probative, that it helps the prosecutors get to some other evidence, that it answers some critical questions, that it helps the jury figure out what the prosecutors are trying to prove, and that the prosecutors can't get to that same evidence in some other way. So these are pretty tough standards. There is relevance. It has to be probative. It has to help the prosecutors, get to something. It has to relate to some factual occurrence. It can't be mythological or allegorical. So these are pretty tough standards. And now let me point out one very important thing about this act. One very important thing. And that is, okay. All right, creative and artistic. I'm at the top of this page. Creative and artistic expressions inadmissible, except as provided in subsection B, evidence of a defendant's creative or artistic expression, whether original or derivative, is not admissible against such defendant in a criminal case. Exception: a court may admit evidence described in subsection A if the government, in a hearing conducted outside the hearing of the jury, proved by clear and convincing evidence. This is a very important distinction. Very, very important distinction that I'm about to make. And that is, there are different phases of a criminal case, right? So the first phase is, that an alleged crime occurred. And then there's typically an investigation of some sort. And then pursuant to that investigation, law enforcement will swear out an affidavit, unless they have probable cause to arrest someone on the spot. Oftentimes, like with this type of case, they spent months investigating it. And then once they completed their investigation, they went to a magistrate with an affidavit laying out all the things or all the reasons why they believe there's probable cause to issue an arrest warrant and indict this person. So they went to the magistrate for the arrest warrant, went to the grand jury for the indictment. And here's the thing. Here's the distinction. They can use the lyrics. They can use the lyrics to get the arrest warrant. They can use the lyrics to get the indictment. They just can't use the lyrics if this bill becomes law in a federal case after the case has been filed. After the case has been filed. But in order to get the case indicted, they can still use the lyrics. This doesn't say anything about not using lyrics, violent lyrics, to either get the search warrant or the arrest warrant or the indictment. it can't be used after the case has been filed to convict the person. It can be used to arrest, to search, and to indict the person, but it cannot be used if this change to the Federal Rules of Evidence passes. It can't be used to convict the person after the case has been filed. I like that. I like that. And here's why I like that. I like that because homicide is the leading cause of death in the Black community. Among young Black men between the ages of 15 and about 45, homicide is the leading cause of death. That is not true with any other group of men in America. That is only true with African American men. So we definitely have an issue of violence among Black men that we should address. No question about it. All right? And so because our community deals with a lot of violence, I do like this sort of compromise this bill proposes by allowing law enforcement to, yes, bring charges, to search, even indict if someone is rapping about a bunch of violence. But can't use it unless it passes those exceptions I told you about to convict a person. So that, to me, acknowledges the fact that we got some serious violent issues going on in our community. But it addresses the fact that these artists should not be disproportionately or despairingly targeted by law enforcement when you got white artists who sing and rap about equally violent material. So it strikes the right balance to me, right? It says, okay, if you got a person who's a part of some sort of group of folk doing something, singing about it, rapping about it, that can be used to indict the person, to search, to arrest the person. But if this law passes, if this changes the Federal Rules of Evidence, it couldn't be used in a federal case. And by the way, even without this bill, criminal defense attorneys would still argue very strongly against prosecutors using some lyrics in a song against their clients, based on evidence rules. Just based on evidence rules. But I'm here to tell you what you say, and I'm stressing it. What a person says, whether it's in a rap song, whether it's in a letter, whether it's on the telephone that's recorded, whether it's to someone else, whatever, any out-of-court statement that a person makes who is charged with a crime, that statement can be used against them. And it is the reason why we have the Fifth Amendment, right? And it's the reason why in many cases, law enforcement has to warn a person if they're in custody and being interrogated that they have the right to remain silent. And anything they say can and will be used against them in a court of law, and they have the right to an attorney. They give them that warning because the Fifth Amendment protects a person against self-incrimination. But if folks are just out here voluntarily singing and rapping about acts that they committed, then, even this particular bill will not help them if it passes because of those exceptions. So I think I support this bill because I think it strikes the right balance. As a criminal defense attorney, I fight vigorously, Chloe and I, for our criminal defendant clients. And, and we are very, very, very zealous about keeping statements out that they made. But then at the same time, we warn people not to make those statements. Keep their mouths shut. Don't talk to the police. Don't let your child talk to the police because, or anyone else, if they or you are the target of a criminal investigation, because what you say can and will be used against you. They tell you that because they intend to use it. Yeah, but if I talk to them, they may give me a break. They're not going to give you a break. Their job is to prosecute you. They're not going to give you a break. All right. Anyway, I have done several videos on this topic. Please go to our channel and watch those videos. So I think this bill strikes the right balance. So I support it. I think it's good. I hope it passes. I encourage you to call your congressperson, your senator, and tell them to help get this through Congress. And it will pass the House, no doubt. Folks who agree with this bill control the House, the Democrats, the progressives. But whether it gets through the Senate is a whole nother issue. So that's who you really need to focus on. Okay? Let's see now. The other thing I want to say about it before I leave this segment is, it slipped my mind, it'll come back to me. It'll come back to me in just a second. All right, yeah, I'm sorry, slipped my mind. Okay. I'm trying to give myself time to think of it. While I'm doing that, I think there are some comments on Facebook. Let me see what they are. Let me see what comments there are on Facebook. Hello, Facebook family. Hope you all are doing well. Okay. Yes, my good sister, my dear sister Ave. Sister Ave, Audrish, she says, no, I never heard Mr. Cash's song. Yeah, probably most of you have never heard of Johnny Cash's song, but I grew up hearing it. My mama used to tell me when I was young, he had that deep baritone voice. Son, when you grow up, don't you never play with guns, but I shot a man in Ringo just to watch him die. And he would go very low in his register. And when I see that train, he's in Folsom Prison is what he's saying. And when I see that train a-coming, I hang my head and cry. All right. So, I'm just, just kind of making fun of that here. But, I grew up hearing Johnny Cash's music. All right. I'm still trying to think about whether or not what I forgot. But let's see here. We got a couple comments on YouTube. Kanye West would say, this is Truth Rising TV. Welcome to the show. Truth Rising TV says Kanye West would say different, but you would tell him to be quiet. I would tell him to be quiet. Absolutely. Definitely. And I think I know more about this space than Kanye West. Now, if it comes to beats and music, I'm going to listen to Kanye. All right. I don't know a thing about putting some beats together. This dude knows what he's doing on that level. But he needs to listen to me and other lawyers, and all of us would likely tell him and everyone else, zip it. Don't talk. Can be used against you in your music. All right. Truth Rising TV says any black musician like Kanye who support Trump gets silenced like it's the 1800s. The racism is disgusting. All right, so Truth Rising TV here, I think is saying that since Kanye supports Trump, Kanye experiences racism. Okay, I don't support Trump. In fact, we're getting ready to talk about Trump. So Truth Rising TV, hang on. We're coming to Trump in just a second because of all the things that has gone on this past week and over the last year and a half having to do with Trump. So we're coming to Trump. Before we do, let me please get a little water here. Just a little water. All right. Trump. Talking about Trump now. Can't remember what I wanted to say, and it was important too. It might come back to me. Anyway, Mr. Trump. Let's go to Mr. Trump. Holding Trump accountable. That's the name of this segment. Holding Donald Trump accountable. All right, so we all know that this past week, the Justice Department, along with the Federal Bureau of Investigation, executed a search warrant on Donald Trump's mansion in Florida and found a number of classified documents. Found a bunch of them. Okay, that's what's being reported. And wow, this is unprecedented. I'm not a presidential historian, but it's my understanding that this has never happened in U.S. history. And all the MAGA people are going to say exactly. That shows that this is politically motivated. Okay? Well, I'm not here to argue that point. This is not a political show. This is a legal show. I'm going to talk about the search warrant. I'm going to talk about that sort of thing. I'm not here to argue the politics. But executing a search warrant on Trump is unprecedented. But so are many other things having to do with Trump's presidency. For example, only president in history who has been twice impeached. Only president. And to my knowledge, the only president in history who kept that much classified information in his personal possession. And the one news outlet, I believe it's the New York Times or the Washington Post, one of the two, is reporting that some of those documents are nuclear related. So for all the MAGA people who are saying Trump is getting politically attacked, hopefully you can admit him and some of the things that he has done and said are just unprecedented. Okay? All right, anyway, his mansion was searched. And to sort of show you and to dispel this notion that he is being, he's a political victim of the progressives and the Democrats. And I don't know, I'm not a politician. Maybe there is some political stuff going on. Those are politicians. I mean, so you mean the Democrat politicians, the GOP, and by the way, I'm neither Democrat nor Republican. I want you to know that before I wade into this issue. I'm neither. I'm not a partisan at all. All right. Now, I didn't vote for Donald Trump. Okay. Did not vote for Trump at all, either time. And, but I'm not a partisan, not GOP, not Democrat. Now, I'm going to go through the timeline of this. And this to me shows that Mr. Trump put the Justice Department in a situation where they got to do something, where they had to do something. Now let's look at it. These are just the facts. Okay? And so look at the picture here. This is Mr. Trump and Mr. Merrick, former President Trump and current AG, Merrick Garland, pardon me. And let's look at the timeline. So we all know that Joe Biden, well, I was going to say we all know that Joe Biden won the White House. A lot of MAGA people would strongly disagree with that, but they are wrong. Some 60 courts, many of them GOP courts, looked at every lawsuit that the Trump administration filed, and every one of them, they lost every one of them. And even in GOP-led states, Georgia, Arizona, etc., Pennsylvania is not GOP, but Georgia definitely is, and Arizona, they said, no, you lost, okay? You lost. And during the January 6th hearings, people like William Barr, his daughter, Ivanka Trump, I think whatever her name is, his daughter, and who else? I mean, just many other officials, the vice president, the vice president's assistants, Georgia officials, like I said. I mean, one after the other, very loyal Trump people said no. The people who were over the attorney general that he appointed, all of these people said, no, Mr. Trump, you lost. Joe Biden won the White House. All right. And we know what happened with that. We had the January 6th insurrection. So Trump falsely claims he won the election with the help of Giuliani and others. Okay. Now, Trump left the White House on January 20th, 2021. Okay. And I wrote some notes down, and I'm going to stick pretty close to my notes. I'm going to, kind of read them. On January 20th, 2021, Trump left the White House. His administration gave some documents to the National Archives Office, the National Archives and Records Administration. However, Trump falsely claimed some of the documents created during his administration belonged to him, and he took many of them with him in violation of federal law. Those documents do not belong to the president just because those documents were created under their administration. Those documents are government documents, and they go to the National Archives. That's where they're supposed to go. So the National Archives spent all of 2021 negotiating with Trump to retrieve the documents. Okay? All of 2021, they were negotiating. See, the public doesn't know that. All of 2021, they negotiated with Trump to get the documents. Okay? Sometime in January of 2022, after a year, Trump turned over 15 boxes of documents to the National Archives. For a whole year, Trump had those documents in his mansion down in Florida. For a whole year. He had these and you remember when he was campaigning, Trump and his supporters were like, lock up Hillary Clinton for using email servers that were not government, her personal email servers. So lock her up, lock her up, lock her up, lock her up. Yet you don't hear anything about the fact that the former president had 15 boxes of, that's not all. He turned over 15 boxes after a year negotiating with the National Archives. He gave it to them after a year. And when they went through it, they found classified documents that Trump had in his possession for a year. I mean, what? Okay. Now, what the National Archives said should have happened is when Mr. Trump and his administration left the White House, they should have handed over all of those documents directly from the White House. Instead, Trump apparently took documents down to Florida with him, classified, highly sensitive documents, and had them for a year before he turned them over. So, after a year, the National Archives, after a year, they referred the matter to the Department of Justice. For a whole year, they didn't do that. They just negotiated with Trump and his lawyers. Just give us the documents. They don't belong to you. Give us the documents. Okay. And he didn't. So eventually they referred the matter to the Department of Justice. In April 2022, just a few months ago, federal investigators opened an investigation. And sometime around that same time, a group of federal investigators and Department of Justice counterintelligence officials traveled to Trump's mansion and discussed the documents with Trump and his lawyers. I mean, they're going out of their way to get these documents and to show Trump, a former president, due respect. No one else would have got all that deference. Okay, I'm a criminal defense lawyer. I'm telling you, my clients don't get to do all that. Okay, they don't get all that kind of deference. But he got all kind of deference here. All right. In May 2022, the DOJ subpoenaed the documents from from the National Archives, and interviewed some White House officials. And it's reported that those White House officials were interviewed to see if they were good, candidates to speak to a grand jury. That's what's being reported. That was May 2022. August 8th, 2022, FBI agents executed a search warrant on Trump's mansion down in Florida. Now, that was a year and a half after he left the White House and after, with all that negotiation going on. And let me say this, as a criminal defense attorney, and I say this, I don't care who it is, and I believe it with all my heart as a criminal defense attorney. Donald Trump is presumed innocent, even if the Department of Justice thinks he has committed a crime, or if they get a federal indictment of him, which would just be completely unprecedented. He is presumed innocent, just like Young Thug, just like any other criminal defendant. He is presumed innocent under our law. I want to put that out there. These are allegations. Now, some of these things, though, are sort of factual. Even Trump acknowledged that a search warrant was executed in his house, and he said in a statement that whatever the Department of Justice retrieved, then release it. So he's acknowledged that this has happened. All right. So I'm not finding him guilty, in my assessment, because again, he's presumed innocent. But he has acknowledged certain things. So the warrant was executed on August 8th. They did find some documents. I'll talk to you about that in a moment. Those documents are reportedly related to some of the most highly classified programs by the United States government. According to the New York Times, the government has been concerned that the documents are related to something called special access programs. I don't even know what that is. And the New York Times says that's a designation that's reserved for extremely sensitive operations carried out by the United States abroad, or for closely held technologies and capabilities. This really, honestly, brings chills down my spine to know that these highly classified, sensitive documents were in somebody's mansion, and all kind of people had access to them. I mean, having to do with with very sensitive, they're saying, operations, technologies, capabilities. What? Okay. I'm holding back. Okay, I'm really holding back. Even more concerning, the Washington Post reported that some of the top secret documents were related to nuclear capabilities, nuclear weapons, which could have been a part of this special access designation. Folks, that concerns me as an American citizen. Okay? So, after a year and a half of trying to get these documents back, Merrick Garland was put in a position I presume no attorney general would ever want to be put in, and that is signing off on a search warrant of a former president, especially during a time when the country is this divided. Who would want to be in that situation? But then at the same time, we boast about being a nation of laws, not of men, that no one is above the law. So if the Department of Justice is going to have any credibility, if our country is going to have any credibility, it can't just overlook this just because, Trump is a very popular person and a lot of people support him no matter what. It was Trump who actually said, I can shoot somebody on Fifth Avenue and my folks going to still be with me. I mean, he said that. So, I mean, A.G. Garland was just in a very, very tough position. So he made a move, and I think it was a pretty smart move. He said, okay, let's release some of the documents, or let's release some of the, not documents, but let's release some of what has happened over the past year. And so he filed a motion and asked the federal judge down there where Trump's mansion is, to release, to unseal certain parts of this search. And the parts of the search that he asked to be unsealed, and Trump agreed with him, was the search warrant, all right, the attached affidavits, but not the documents themselves. So the search warrant, the attached affidavits, and the inventory. Forgot that, the inventory. Okay, but not the probable cause affidavit, which the investigators used to show that there was probable cause to issue the search warrant. So we see that all the time in our practice. All right, all the time in our practice when we are representing someone, we want to get a copy of the probable cause affidavit that law enforcement used to get the arrest warrant in the first place. We want to get our hands on that because we want to know what it says, what they're alleging, and what evidence they got. Well, in this case, Merrick Garland said, no, we're not going to ask the court to unseal that. We are going to ask the court to unseal the search warrant and the attachments and what we found, or at least a description of what we found. And I presume A.G. Garland came to that conclusion or decision because Trump was again assailing him and the FBI and the Department of Justice. And these are, there were people out there saying they planted evidence and this is politically motivated and so forth. And so A.G. Garland said, okay, well then let's show the American people whether this is politically motivated. Let's show. Let's everybody show their hands. Okay? And it was a great move. And so as a result of that, we were able to get the search warrant. And the search warrant, based on an affidavit, we didn't get that. the probable cause affidavit. We didn't get that, but we did get the search warrant. And we did find out what, in fact, they were able to retrieve pursuant to the search. Okay? That, what you're looking at here is the inventory. This is the inventory. This is what they actually retrieved. And you should be able to count. It's a little far from me, but you should be able to count that there are a number of boxes right there and some documents. Okay? This is what the FBI completed once they retrieved these items. They made an inventory list of all of this. And here's an even longer list, many other boxes. This is what they were able to retrieve pursuant to their search. This is what they were trying to get for the last year and a half. All right. Here's another list. So let me show you. 3 pages of documents and boxes of documents that they recovered from Mr. Trump's mansion. Now, the Washington Post described those documents this way. The written inventory, we just read that. A document provided by investigators after search says the FBI took about 20 boxes, it's actually more than that, of items from Mar-a-Lago Club on Monday, including photo binders, information about the president of France, and a variety of classified material. One set of documents is listed as various classified TS, SCI documents, a reference to TS means top secret, SCI means sensitive, compartmented information, a highly classified category of government secrets, in addition to the 4 sets of top secret papers. Agents who took these 3 sets of documents classified as secret and 3 sets of papers classified as confidential, the lowest level of classification. This is what they retrieved. After a year and a half, Mr. Trump left the White House January 20th, 2021. It is when this search warrant was executed, August 8th, 2022. That is a year and a half later that they negotiated and tried, as Merrick Garland actually said in an interview, in a press conference that he did. We tried less intrusive measures to get these things. Mr. Trump released a statement saying all they had to do was ask. All they had to do was ask, and we would have given it to them. Well, when you look at the timeline, you see that that's false, because they asked for a year and a half. For a year and a half, they asked, even visiting the Mar-a-Lago mansion. So it wasn't true. Just the request would have been sufficient to get these documents, and therefore the search was just political fodder. It's not true. Not based on what we see here and what we know. Now again, Mr. Trump's presumed innocent. I'm just telling you, I'm just laying out the timeline. All right? It really, honestly, as an American citizen, just gives me chills to know that these sensitive documents, maybe even some nuclear documents, was in the possession of Trump, his lawyers, his cooks. I mean, God knows who else had possession of these things. I mean, this is, I have no words. So, it falls on deaf ears to me when I hear folks saying that this was political. because as a criminal defense lawyer, I know that my clients don't get this kind of deference. Nowhere near this. Now, we're not talking about former presidents. You know, I haven't represented a former president, but we're supposed to all be the same under the law, right? That just because someone has money, power, fame, or because they're of one race or another, they shouldn't be treated different. Yet that's exactly what happened. And I'm telling you that not as a layperson, but as someone who has represented hundreds, maybe thousands of people in the criminal court system. Government doesn't give that kind of deference. They gave Mr. Trump all kinds of deference here. Whether he's committed a crime, I don't know. They alleged in one of the attachments to the warrant that he potentially violated 3 different federal statutes, one having to do with espionage, spying. Whether he in fact violated a statute, I don't know. And again, he's presumed innocent. So the presumption is he didn't. Other statutes having to do with, destroying documents, secreting documents, obstructing justice. Whether he's done any of that, again, we must give him the presumption of innocence, the same presumption that we'd want everyone else to have, including ourselves or our loved ones, etc. But it is hard to deny that he had those documents. He basically admitted it. Now, whether one of the things that he says is he declassified them. He declassified those documents, so they were not classified. Now, I don't know whether or not that's true that he declassified them, or even if that matters. Even if he declassified them, I still don't. It seems to me it's still problematic for somebody to have top secret documents, government documents that don't belong to them. Nuclear documents. So a president can just say, I declassify this nuclear material and just keep it when they leave office. That doesn't make any sense to me. But I don't know. Time will tell. Time will tell. All right. It is very important that, as we say here in the title, that Mr. Trump is held accountable. It's important for African Americans and everybody else, all citizens. But someone said last week, for example, that black men are not held accountable under the law. It was the most outrageous statement I have heard in some time, when black men are disproportionately prosecuted. Although black men do not commit most of the crime in this country. And there's proof that black men are oftentimes the victims of racial profiling, of overzealous prosecution, biased police officers, biased judges, et cetera, et cetera. So it's not true that African American men are not held, are not accountable to the law. But oftentimes we do see people who have money, whites, especially wealthy people, wealthy whites, we do see them being treated different under the law. It's not even debatable. There are 2 criminal justice systems here. I think Brian Stevenson, the civil rights attorney, famously said that you could be guilty, you'd do better guilty and white if you were not guilty and black and rich in our criminal justice system. All right. Okay. Truth Rising TV says Obama has 33 million classified documents. I am so glad you said that, because that reminded me that the National Archives refuted that. They refuted that and said every document that Obama was created under the Obama administration, the National Archives released a statement in direct response to Trump's claim, because that's what Trump said too. Obama had classified documents, and the National Archives released a statement and said that's false. We have control over every document in possession that was created under the Obama administration. So Truth Rising TV, that is false. That's refuted by the people who are tasked with the responsibility of keeping documents by former presidents. Okay, that is going to be the end of our show. I did it all by myself here without my daughter and partner. Before I get out of here, and by the way, Truth Rising TV, we do certainly appreciate you tuning in and commenting today. Absolutely. All right. Sister Ave said, Sister Ave says, this is just unheard of. Mr. Trump does not even have the capacity to understand the magnitude of his behavior. He does not believe he has any accountability. If they were true, then why did they have to wait 1 to 1.5 years in order to get the documents? A very dangerous individual has had possession of the secret information. All right. Sister A points out that the retrieved documents from the toilet, that they retrieved documents, and in fact, the National Archive confirmed that some of the documents that they did receive from the Trump administration when he first left the White House were, torn and ragged and so on. So they confirmed that. That's not, that's not just rumor. Okay. All right, so I think this is going to do it for us. This is going to do it. I've enjoyed it. I really enjoyed it, going through everything. Hope that you all were inspired, informed by this. Okay? Remember, we're on the air every Saturday from... try to get on at 2:30, somewhere along there, every Saturday, so that we can, again, empower you with a legal analysis of trending politics, policies, personalities, and pop culture, so that you can defy this unjust legal system. I'm going to give myself an applause for doing all this today. All right, that's the end of it. You all have a good one. Thank you for joining me. Peace.